Hey, good morning, everyone. This is Clint Coons with Anderson Business Advisors and Law Group, and I want to thank you for joining me on my office hours. If you're not aware, this is a new program I'm starting that I hope to, well, that I plan to bring to you each and every week on Wednesday, where for an hour I'll be here to answer your questions. And I know a lot of people out there have burning questions when it comes to real estate investing, taxation, asset protection. And at Anderson, if you're not aware of what we do, I mean, that's our specialty. I myself am a real estate investor, an attorney, and a small business owner. So I bring a lot to the table when it comes to understanding how businesses work, and especially how asset protection relates to investing. Because if I myself haven't done it with my own investing, then I've had a client that's probably been engaged in it, and I have spotted the issues, dealt with those issues, and had satisfactory outcomes for my clients in protecting their assets and reducing their taxes. And as you know, this is an evolving area of the law. That is, things change, and you have to make sure that your strategies change as the market is changing. Things that used to work 5 or 6 years ago, those strategies, not all of them work today. And many times you can spot those issues right away. When you look at the structure and people are not having success with what they've set up, it's because certain aspects have changed. And so what I want to do is make myself accessible to you through these office hours. And in order for you to ask the questions, the way we're going to go through this is that if you have a question, I'd like you to raise your hand, and on your program you should see there's a little icon for you to raise your hand up, and then what I'll do is I'll unmute you, drop your hand down, and then you'll be free to ask your question, and we'll just have a dialogue. All this will be recorded, so if you have to step out early and you want to hear the questions that were asked that you weren't able to listen to, I'm going to post this on my blog today. If you're unfamiliar with my blog, it's you can just go to my website, clintcoons.com, and then click in the upper right-hand corner. You'll see access to my blog. It's a WordPress blog, so otherwise you could just type in my name plus WordPress, and you'll find this webinar or this recording, the audio recording of my office hours, available to you. So with that, I'd like to get started right away. If there's anyone that has a question, I see right now, Brian, you have a question. I'm going to unmute you. And there you go, Brian. Hi, Clint Coons. How you doing?
Excellent, Clint. Good to hear your voice again after attending your webinar. And I'm getting organized and following through with what I learned during the seminar. So my first question would be, okay, so we're working with an Anderson advisor, and we currently have a business set up as an LLC, but we're being assisted with the creation of a C corporation to hold the LLC. So we're doing a little reshuffling, and as the owner of the LLC will be that new C corporation, and the owner of the C corporation is going to be the Nevada holding company, and then that's kind of paints the picture of how we are structured currently. But we also have some rental property that we're forming LLCs by rental property address, and these are going to be managed by a nominee, but owned by the Nevada holding company. And I'd just like to ask if this seems correct, and how do I determine who the nominee will be for the rental property LLCs?
Now, see, the fact that you don't even know, just think of the protection you're going to have here if somebody was coming after you. I mean, if it's your structure and you're not sure who's listed on there, it's going to be doubly difficult for a creditor to figure this stuff out as well. So if you're looking at your screen right now, I've been drawing the picture of what you just described. Is that pretty accurate of what you have?
Oh, yes, it is.
Okay. So with respect to these LLCs that are being created over here that are set up to hold real estate, these LLCs that you're creating, they're all owned by your Nevada limited liability company. which is your anonymity shield. And so if you want to create an anonymity compliant limited liability company, is how I like to refer to it, then you create a Nevada LLC that does not have your name attached to it. Now, this could easily be a Wyoming LLC as well, but it needs to be an LLC that offers anonymity. So we use a nominee. On your LLC that you've created with us, it will state that A.T. Mathis is the manager of that limited liability company for the public's, from the public's perspective. So that's the information that's provided. Now, A.T. Mathis has resigned his position, and he has appointed you as the manager of your Nevada LLC. So this puts you in control. You run it, but nobody knows that you have it because they can't trace it back to you. So that's the first step. The key is to get this LLC set up right here in Nevada or Wyoming, and then once we've established that, we can go and create these other LLCs that are designed to hold your property in these other states. And by doing it in this manner, when we create, let's say this LLC over here on the right was going to be set up in Florida. The Florida LLC points back to your Nevada LLC. So if anybody looked at the Florida LLC, and let's come up with a name with it, we'll call it Scotch Investing LLC. They will notice that Scotch Investing LLC is owned by a Nevada limited liability company. So if they wanted to dig a little deeper into your structure, they will then notice that this Nevada LLC that owns the Florida LLC is controlled by an individual named A.T. Mathis. And if they ran his name, they're going to find he controls 17,000 other entities in Nevada. So you become a very small fish in a large pond of entities where A.T. Mathis is protecting the identity of the clients. So that's how your structure is set up. Does that make sense?
Yes, and then I understand we would only do 2 tax returns in this scenario, one for the C-corp and one for the Nevada holding company?
That is correct. So your Nevada LLC is going to be created, set up as a partnership. So it will file a 1065 return. And the C corporation, okay, it has to file an 1120. Now, if you're wondering why the C corporation shares are owned by your Nevada LLC, well, there's a asset protection reason for this, and that is the shares themselves do not necessarily provide any protection. That is, a creditor could take your shares, whereas in an LLC, they cannot take your membership interests. So a way to protect shares in a C corporation is to have those shares held by an entity that has charging order protections. Your Nevada LLC is that type of entity. It offers charging order protection, so if somebody were to sue you individually and they were to ask, what do you own? In your scenario, the way you've described it, the only thing you own is an interest in a Nevada LLC. Although I drew on this screen, well, with 5 different boxes, you only own 1 box. And so in order to climb into these other boxes to gain access to it, a personal creditor would first have to defeat the Nevada Limited Liability Company. And we know that's not happening because Nevada has set up their laws to keep creditors away from business owners.
Thank you very much, Clint.
No, you're welcome.
Another question, but I can wait and let some others ask a question before I ask the next question.
Well, nobody's raised their hand yet, so if you want to ask,
okay.
Feel free.
Okay, following the same scenario then, with the C corporation, I understand, like my wife and I currently pay for our long-term health care, and I understand that there'll be tax advantages and also some tax implications with the C corp. We might be paying, you know, and previously with just the LLC, everything passed through to our personal tax return, but with the C corporation, we'll be able to take some tax deductions for the long-term health care coverage and things, but we're going to have to pay a reasonable for our business, reasonable salary.
Correct. All right, so you brought up a couple different things there that I'd like to make mention of to everyone. Number one is, yes, with the C corporation, you have a tremendous amount of deductions that are available to you. And the benefit of having a C corporation is that those deductions are taken at the corporation's level and not on your individual 1040, which when you take a lot of deductions on a 1040, they're typically going to fall on your Schedule C, or if you're a real estate investor, we'll bury some of them in Schedule E. Wherever we're putting those expenses or those deductions, you're increasing the likelihood of an audit, because we all know that 1040s are audited far more than 1120s, and then followed by 1065s, which are partnership returns. So we want to isolate out these expenses so that we're not even a blip on the radar, and we're running them through our corporation. So that's one benefit of having that C corporation. But more importantly, and this is something that I've started to focus on more and more with my investor clients, and that is by having a C corporation, if you're a real estate investor, it's going to provide some ancillary benefits to you that may not be recognizable. And the story I like to share with you is one where an individual went to a local attorney here in Washington State and sought some advice on how to structure his flipping business. So this individual is buying and selling real estate here in Washington, and he decided he needed some asset protection. Now, prior to him going in and seeking any advice, I mean, he's been treated as a sole proprietor. Everything's been listed on his Schedule C because he's actively engaged in the business of flipping real estate. So it's an active trader business for him. The attorney told him to set up a limited liability company. And he said, you need to talk to a CPA about the best way to have it taxed. So the attorney he went and met with was focused on the asset protection component of this individual's investing. He went to the CPA, and the CPA told him, yes, you can set up an LLC, but it needs to be taxed as an S corporation, because I want to help you minimize your taxes on your earnings from your flipping of real estate. And the way they do that with S corporations is that, let's say I earned $100,000. Rather than take the full $100,000 as a salary or have it all show up on my Schedule C as active income, what you'll do is you'll pay yourself a salary, a reasonable salary, and you use that term yourself, of, let's assume, $50,000. That $50,000 is going to be subject to employment taxes, 15.4% taxes. Employment taxes will be paid on that salary. The $50,000 that is distributed out to you as a distribution is unearned income. So the salary is earned income, the distribution is unearned income. So that $50K that comes out to you is not subject to that 15.4%. So from the CPA's point of view, by creating an S corporation for this particular investor, what he's allowing him to do is minimize his employment taxes. And in this case, he would save $7,000 by utilizing that strategy. Now, as real estate investors, we look at that, and when we're looking for tax savings, you think, wow, that's the approach I should go with. I should set up an LLC for the asset protection. I should have it taxed as an S corporation to minimize my employment taxes. But there's another component to investing that neither the attorney nor the CPA understands, because they're not real estate investors. And when the individual walked into my office and he explained to me exactly what I just shared with you, I said, you want to start with a C corporation. You do not want an entity tax as an S corporation. Yes, you could set up the LLC, have a tax as a C corp, that's fine, but we want C corporation tax status. And basically his mouth hit the table. He said, wait a minute. The CPA told me that's not what I want to set up. And I looked at him and I said to him as follows. I asked him this question. I said, currently you're buying and selling property. Where do you obtain funding? He said, well, you have to use hard money lenders. And my second question then was, do you have equity in your house? He said, yes, I have about $300,000 to $400,000 in equity in my house. I said, I bet you cannot tap that equity. But if have you gone to a bank and tried to access the equity? He said, I have, and they will not lend me any money against the equity in my property. And I asked him, I said, do you know why that is? He said, well, it's because of my tax returns. I said, that's exactly right, because right now you're showing all of this income on your Schedule C, so you're a risky borrower. And the lenders do not want to lend to you as a Schedule C filer because of the nature of your business activity. You're a real estate investor, and lenders are scared of real estate investors. So if you take the CPA's advice, you're not going to be in any better situation. You're still going to have a hard time accessing capital, because at the end of the day, your business runs on capital acquisition. That is, do you have lines of credit that you can tap into to go out and buy more real estate? Wouldn't you like to be in a situation where you could access lines of capital at 4.5%, gain the access to the equity in your property, rather than continuing to have to use hard money lenders and paying 10 and 12% on your deals? He said, that's what I've been looking for. How do I gain that access? Do you have anybody that loans money at those rates? I said, of course I don't, but what you need to do is you set up a C corporation. And by setting up a C corporation, you then become a W-2 wage earner. You become an employee of that company. You take everything out as salary. You create a big fat W-2. And when you go into your lender now, you don't tell them you're a real estate flipper, that you're a dealer in real estate. You just say you work for a company. Here's your W-2. This is how much you make on an annual basis. They'll get copies of that. And then you look much better in the lender's eyes because you fit in their box. If you adopt this S corporation, which is a pass-through entity, then that corporation shows up on your tax return. And when you go in to borrow money, they're going to want to see a copy of the S corporation's tax return. And again, this is where you run into even more problems. And I pull my hair out when I hear CPAs tell people this, because if you're like me, you're going to run your business. And you already started talking about this, Brian. How do I expense out my long-term care insurance? How do I expense out my medical insurance? What other deductions do I have? Your concept of running a business is to make your business work for you. You want to take available of every tax deduction there is out there, and by doing that, you're spending pre-tax dollars. So you're reducing your taxable income in that corporation and possibly even netting it out because you're pulling so many benefits out of it. So from a tax standpoint, you're capitalizing on the benefits of incorporating. But the problem is, from a lender standpoint, when they look at that tax return, if you've done everything right, your corporation makes no money. So they're going to look at you and say, so you want to borrow $200,000, or you want us to loan you up to $300,000 against the equity in your house. Well, it appears from your tax returns that your corporation is not profitable. Then you have to go back to your lender and say, well, wait a minute, I expense everything out. It's designed to look that way from a tax standpoint, but really I make money. Well, that's not going to work with the underwriter. So this is the problem so many investors face when they set up S corporations. It sounds great on the outset, but when they go in and they start actually running their business, they're going to have problems getting access to capital. Lenders are going to be questioning how they're running their business, why they're not profitable. And I'm telling you this not only from dealing with clients that invest in real estate, but it's also from firsthand experience, because Anderson is set up as an S corporation. And we do that for tax reasons, because to be a professional and run it through a C-corp, there are some negative tax consequences with professional corporations. But it's a problem that I face with my own investing. When they look at Anderson's tax returns, there's always that tug against, do we want to expense everything out, or do we have to show income inside of the company in order to look better for lenders? So I hope that gave you some insight into that. A little longer than I anticipated.
Oh, no, thank you very much. And that kind of leads to another question, but I can also hold off in case you
hold off on that one, Brian. Yeah, because I want to get some other people. Thank you.
You're welcome. Thank you.
Yeah. All right. Adeline, you're up next.
Hi. Can you hear me okay?
I can hear you just fine.
Okay, perfect. I'm not used to this webinar stuff, and I'm very, very new. So I need the For Dummies version of the real estate investing. We're just starting to go in that direction, and we're just and I am trying to wrap my brain around the C-corp, the whole thing. I apologize. I almost feel like I need a tutorial on it.
Okay. Yeah. Not a problem. I mean, I understand. So you're starting off, and there's all this information out there. If you go on the internet and you put in real estate investing, proper type entities, you're going to get inundated with information.
Yep.
First off, be very careful on what you read, because a lot of the people out there that talk about asset protection as it pertains to real estate investing, they're not real estate investors themselves. So they don't quite understand the nuances of creating the proper structure. So that's one problem you face. The second problem that you have to be aware of is that the individual you're dealing with, do they understand the type of investing you plan to engage in, and are they going to set up a structure that is in your best interest? You know, yesterday I met with a new client that came in, and she went to, I think it was called U.S. Tax Liens and Associates or something like that, went to their event, and she was told that she needed to create a Nevada LLC to sponsor a pension plan that would in turn own a separate LLC so she could buy real estate. So they set up a Nevada LLC for her to sponsor a pension plan, and then that pension, self-directed pension, owned LLC in Wyoming that held property in, I think it was Missouri and Indiana, if I recall. So she said, what do you think about this? And I said, well, you've overcomplicated the situation here. You do not need this type of structure. You know, the Nevada LLC, if you're starting off and your idea is to buy and sell property in your retirement plan, there's no purpose in having that entity. What we should do is just take your existing corporation, because she has an up and running business in Washington State, hook the pension to that, and then have the pension go out and buy the property. And we could possibly use an LLC, but that LLC will need to be registered in the state where you own the real estate. And so what I'm explaining to you is that it's not a one-size-fits-all approach when it comes to investing. So as a beginning investor, you first have to ask yourself, A, what do I want to do with my investing? Do I want to buy and hold, or do I want to flip properties? 2, or B, I don't want to go A to 2, it goes A to B. B, you got to ask yourself, where do you plan to engage in this activity? Now, when we were talking with Brian, he has a very complicated structure. He has a structure that offers anonymity. Now, you as a beginning investor, do you need something as complicated as Brian? Probably not.
Yeah,
probably start a little simpler.
Right, I want to start out very simply. Here's our story. My husband, our business, our company is RWP Construction, so we do remodeling.
Mm-hmm.
And we kind of semi fell into rentals, not totally. My husband took like a real estate investment course that was pretty much not very helpful, that he paid a lot of money for years ago. And through that, he purchased a property in a not really good neighborhood, which created a lot of problems for him, and we eventually sold that property. And then I married him and moved from one side of the state to the other to be under the same roof. So my private residence became a rental.
Okay.
And then I recently retired from corporate America, and I rolled over my pension lump sum and my 401k into a self-directed IRA, which, coming from no understanding or background about financial concepts or vehicles or things, with the little bit I knew, I was buying some precious metals for my self-directed IRA, and then came across a wonderful opportunity to purchase the house across the street from where we live, as is through what do you call it, an estate. And
all right, so your self-directed IRA owns a rental now, correct?
Yeah, it owns a rental, and got that fixed up. It's now rented, so it's now positive cash flow into the IRA, of course.
Mm-hmm.
Now, our business has an LLC. However, we've been taxed out the wazoo for this past tax year that I'm about to turn in here, not too long, because we also flipped a house in this past tax year, which was about $30,000 in, what's the tax that you get when you flip a house?
This is all going to be active income to you.
Right. So, but there's a special tax for real estate, not unearned income.
Well, you're considered to be a dealer, but you're already in it. So you flip that property, you made $30K. Your construction company, how is it taxed? Is it taxed as a corp or an S corp or a partnership?
It's just an LLC, so it just passes through to our income.
Okay. Does it file a tax return?
Good question. I
All
don't
right.
think so. I think
So do you have any employees?
We did last year have one employee.
Full-time?
From August, full-time from pretty much full-time from August through the middle of December when he resigned.
Okay. Here's what I would recommend. Just based on the small amount of information you provided me, I've seen a couple of problems here. Number one, you're running your business as a sole proprietorship from a tax standpoint, so you're receiving no tax breaks other than what a sole proprietor can obtain.
Right.
You've taken your pension money, 401k money, whatever, put it into a self-directed IRA to gain access to those funds. The problem with the self-directed IRA, if you look at my blog, there's a number of issues. The IRS is targeting self-directed IRAs, especially self-directed IRAs that own real estate.
Oh boy.
The self-directed IRA doesn't give you any tax breaks as well. So if you wanted to change your situation to improve it for 2016 to minimize your taxes so you're not facing this issue that you are come April 15th next year, I would take that LLC, tax it as a C corporation, set up a qualified retirement plan.
Okay, I'm writing it all down. So you would take the LLC, you would tax it as a C corp.
Yes, and we have a very limited window of opportunity to do that for this year.
So
we want to
date?
get that change of tax. We have 45 days, so it comes till February 15th to make the change of accounting election.
Okay.
So we want to change it to a C corp.
Okay.
Then we want to set up a qualified retirement plan off of that company
retirement plan. Okay.
that you're allowed to direct your investing in. Now, what is this going to provide you and your husband? Well, it's going to give you true access to your retirement funds. Right now in your self-directed IRA, you cannot engage in the transactions without using your third-party administrator.
Right.
You're the trustee, you handle it all. You don't need somebody else telling you when a deal needs to be put together. You can put it together on your own. You can borrow.
Would I be able to roll my self-directed IRA stuff into this other thing? Okay.
Yes, it's not a Roth, is it?
No, it's a traditional IRA that's self-directed that can own different investment things.
You can roll it in there. You'll be in control. You can borrow from it. And more importantly, when we're looking for tax deductions in 2016, you and your husband can start making contributions to this qualified retirement plan. In fact, you could make upwards of just $18,000 each of you, provided you took out $18,000 in salary from your company into the qualified retirement plan as a 401k contribution. So if you add that up together, that's $36,000 that you wouldn't have to pay tax on come next year.
But you can still have access to it to do things.
Full access. You can do so much more.
And my other concern is like how much, initial setup and maintenance fees for all of these corps and LLCs and tax returns, because it just...
That's great.
Yeah,
it adds up. All right. Well, if you look at what I just explained to you, the setup cost for us to set up a qualified retirement plan is $2,500 to set that up. To change your tax election, I wouldn't charge you to do that. How much is that going to save you in taxes? If you were just to contribute, say, $18,000 to the plan, that's going to save you probably around $4,000 a year in taxes. So that's going to actually pay for itself in the first year. But you're also going to have complete control over those retirement funds. You're going to have access to capital going forward. Like I said, if you wanted to borrow money out of your plan, you can. If you want to partner with it, you have the ability to partner with your pension to buy some property. If your husband has an IRA, he could roll his IRA into this, and now you have pooled accounts. So it really opens up the door to full control.
So initially it would cost $2,500 to, but what about changing a plain old LLC that doesn't even have my name on it to a C corp, like he had it before he met me?
No charge. We would include that with the plan setup because we'd have to do that in order to set up the plan.
Uh-huh. And then are you recommending that every single time we're looking at mostly buying houses to hold on to and rent?
Mm-hmm.
So would then I be setting up a separate LLC for each one of these properties that I purchase?
Not necessarily. What we would look at is the nature of the property, how much equity is involved, and then we'd make a determination as to what is a reasonable structure for your investing.
So there's a
You can
range.
overstructure. There's a range. I always treat people like I do my parents, all right? When I graduated law school, my dad was so happy that I graduated because now he had an attorney that was on permanent retainer for life and everything was free for him.
Yeah.
And he said, hey, I want you to set up 24 LLCs and transfer each property into an LLC. And I knew that that's not something my mom would want me to do because that's going to complicate her life.
Yeah.
And I called her up right away. I said, Mom, Dad wants me to set up 24 LLCs. What do you think, since you handle all the books? She said, I think your dad needs to be put on medication.
Yeah.
That's not going to happen. So, you know, and I told her, I said, I think you should group your properties, and I explained to her how I think they should be set up. And so we settled, I think, on 5 or 6 LLCs for all of these properties, and she's comfortable with it, and it gives them some protection. It breaks up, so if something devastating happened, they don't lose everything. And I think it's a reasonable strategy. So that's what we would work on one-on-one.
Okay.
All right?
Yeah, because my concern is biting off more than I can chew.
Yes, take it in steps.
Because we're so just at the ground floor point of starting out. And can you re-explain the part that you explained to Brian about how having a C-corp helps you to get hard money lenders to lend to you, because we're struggling with that issue right now?
Well, I'll tell you what, that question, I want to get some other questions because there's a lot of people waiting.
Sure.
But I'll have this up, the audio up on my blog if you go there, and you can re-listen to it this afternoon.
Can you give the blog
Sure.
address again?
If you just go to clintcoons.com, if you go to that website right there, it'll take you to my blog. You'll see it says my blog up in the right-hand corner.
How do you spell your last name?
C-O-O-N-S.
Okay.
Can you see your screen right now?
I see my screen, but I don't see. Oh, yeah, I see Clint's office hours.
You don't see a white
screen?
screen?
I see what you wrote on the screen. Thank you.
Yeah. Just go to that, and then you can sign up for my blog. So every time I post something, you'll receive notification of it.
Okay.
So you'll get notifications of it. All right. Nice talking to you.
You too. Thanks.
Bye-bye. All right. I'm going to go to Anna. Let me just hold on a second here, Anna. All right, Anna. How are you doing? Anna, you've muted your mic. There you go. Anna, you there? All right. I'm not picking you up, Anna. I'm going to move on down to the next one. We'll come back to you. I believe it is Christiana. Is Christiana there?
Yes, I'm here.
Hi, what can I do for you?
Oh, hi. I am even more new than the last lady. I actually have nothing done yet. I just got interested in real estate investing, myself and my sister and my husband. So we don't own any businesses. We don't even own a home.
All right.
So we're interested in doing flipping houses up front, and maybe doing some assignments or wholesales. We eventually would like to do some rentals, but I don't see that happening in the next 6 months. So initially maybe doing 1, maybe 2 house flips. So my question is, do we need to even open LLCs and C-corps? Should we do a trial run first? Or where do we start?
Okay. I would, what state?
California.
All right. And that's where you're going to be doing your investing?
Yes, to start with, yes.
All right. I would start with the California C-corp is what I would do. And the reason why I'm recommending this is that the activities that you plan to engage in involve contracts. So you're going to be entering into contracts with people to possibly acquire their real estate.
Right.
And every time you sign on a contract, if you're signing in your personal name, you have personal liability. And the statute of limitations for contract claims is 6 years. So you could be sued up to 6 years later for something you did, 5 years ago and you've completely forgotten about. And with real estate, it can there can be problems there. I recently dealt with a situation with one of my clients at the end of last year where they had entered into an agreement with someone to buy several properties at a set amount of money. Well, one of their gap funding lenders backed out of the deal. So they were short $70,000, and closing was, I think it was like 3 days away from the lender backing out. Now, they didn't have access to it, so they called up the seller and they said, we cannot close. We're not going to have the money available. We need to extend closing by 30 days so we can obtain additional gap funding. The seller told them that if they don't close, the seller was going to sue them for specific performance and damages on this particular deal, because this was part of a short sale that he'd negotiated with his bank. So he needed to close. It was imperative that he close so he doesn't lose his short sale deal with the bank. So that's a perfect situation where you don't necessarily anticipate there being liability for you, but because you signed an agreement, if you signed it in your own name, there is. And so for that standpoint, I would start with a C corporation to minimize your liability. So every time you sign an agreement, if you're going to wholesale property, if you're going to buy a property to flip, maybe you're just going to flip it to another investor, you're always signing in your corporation's name. You're going to be an officer of that corporation, so you have liability protection. And then when those deals come through for you, the money rolls into the corporation. You can use that money to pay for your expenses. I mean, have you incurred any education costs to get started?
Yes, we have, actually.
All right. Would you like to I'm sure you would like to recoup those costs and not pay taxes on it. Well, then the C corporation is a prime vehicle to do that, because those expenses will then be attributed to the corporation, and as you make money, you'll reimburse yourself for the monies you spent on your education. And think of it, just if your employer asks you to pick up an iPad from Best Buy on your way back from lunch, and you bought this $500 iPad. When you get back, you're going to give it to your employer. He's going to write you a check for $500. That's not income to you, and it's a deduction to the employer because it was for the benefit of the employer. You're going to have the same situation. So I would start with a C corp.
Okay.
And that's it. Right. Don't go beyond that.
Okay, just a C corp. Got it.
Yeah.
Thank you.
Oh, you're welcome. All right.
Bye-bye.
Take care. All right. Camille. Is Camille available?
Yes.
All right, sir. What can I do for you?
Yes. I open up with Anderson. I have a holding company at Nevada C-corp and a Florida LLC.
All right.
And I did that last year with Anderson. And my question is, I have transferred some of the properties. Well, actually, there are 3 properties in question, which one was in my name, and I transfer it to the Florida LLC through a quitclaim deed.
All right.
And I would just want to know, what are the tax implications? How many tax returns do I have to file? Do I have to file a Florida tax return, or just have to file a Nevada LLC and then the Nevada C-corp?
Okay, so let me back up. Is this a Florida LLC or a Nevada LLC?
Well, I have a Nevada LLC, a holding company, Nevada LLC, and a Nevada C-corp.
All right, perfect. Good structure. All right, and the Nevada LLC, does it own the Florida LLC?
No, the C-corp owns the Florida LLC.
Okay. Is the Florida LLC buying and holding or buying and flipping?
It's both.
Both. That's what the LLC in Florida is engaged in?
Yes. Well, we just started. I mean, I just started it, so it's just.
Now, in this particular structure, if I'm hearing you correctly, you want to know how many tax returns you're going to have to file, correct?
Yeah, the tax returns, and also what are the implications? I've transferred personal property through a quitclaim deed to the corporation, and the tax liability on that one.
All right, so when you transfer the real estate into the LLC, it's a non-taxable event for you. Now, from a federal standpoint. From a state standpoint, the concern is, does that property have any debt on it?
No.
All right, so then there's no taxes from the state side either. With Florida in particular, if you transfer real estate that is encumbered by a mortgage into a LLC or corporation, you will be liable for dock stamps. And the way you avoid that is you first create a land trust. So you create your land trust here, and then you deed your property into the land trust. That avoids the dock stamps, and then you put the land trust into the business entity.
Okay.
So in the future, keep this in mind, that if you have a situation where you're dealing with encumbered real estate, be sure to use a land trust. And one last point, who prepared your deeds for you?
Anderson.
Okay, so all right, just making sure that we took care of that. That's fine. Then your structure, non-taxable, you will have to file a tax return for the C-corp, and the LLC, I'm not sure if it's set up as a partnership or disregarded entity. If it's a partnership, this will require a 1065. If it's a disregarded entity, it will not have to file a tax return. And you can easily figure that out by looking in your binder, in your LLC binder, the Nevada LLC, in the information page, it will explain to you how it's set up for tax purposes. And if all else fails, you just call in.
Okay. Okay. I guess I'll just add on that the other LLC. I have a family member who we had bought the property from before. Transfer it also to my Florida LLC, which is I mean, it's my property actually, but was in a family member's name.
Mm-hmm.
How would that affect taxes on that?
Well, if you bought it from a family member, then it won't affect you. Your family member that you purchased it from, they may have taxable gain on the sale of that property.
Well, we did a quit claim deed because my money initially.
Oh,
so
it was your money.
Back to me.
How long did they hold the property for?
Was a year and 3 months. Yeah, 15
I wouldn't
months.
worry about it. I wouldn't.
Okay.
It wouldn't be an issue. Yeah.
Okay.
All righty.
Well, thank you, sir.
Nice talking to you.
Yeah.
All right. I'm going to go next with Lena Shoemaker.
Hi, can you hear me?
I can.
Okay, cool. So my question is that when you're applying for different lending options, is it better to apply with your LLC, your C-corp, or yourself?
When you're applying for loans, it's best if you apply personally rather than with your entity. There's a misconception out there amongst real estate investors that you can create an entity that can build up its own credit, and you'll no longer have to use your credit when you go in to apply for a loan. And that's just, I have not seen that in my own experience. My business has been set up for 18 years, and whenever I purchase real estate, they always want me to run my personal credit, and they base it on my personal credit score. They do not base it upon my business entity. The only benefit I have with a business entity from a credit standpoint is dealing with business lines of credit. Then I don't have to sign personally. But if I'm leasing office space even, and I can show them my tax returns that my business makes, several $1 million a year, they don't care. They're still going to require a personal guarantee. So what I'm trying to explain to you is don't fall into that trap where people will try to sell you all these expensive business credit programs and convince you that you're going to gain access to different lines of credit where you won't have to sign personally, because it's just not true. It's never occurred in my personal investing, nor have I seen any clients that have experienced that type of success. Does that make sense?
Yeah, and so then let's say you get your money and you buy your property or whatever, then should you immediately sort of like you drew out on the screen, like put that property immediately in a land trust and then into your LLC? Or like how does that process work from going, having the mortgage in your name to putting that property in your LLC?
That's a great question. When you buy that property and you take title in your own name, after title has cleared, it's vested in your name, then you would want to create a land trust and deed the property into that trust. Now, what you do not need to do is contact your lender and let them know that you're engaging in this transaction, because they don't need to know that. If they want to discover it on their own, that's fine. It's not going to create an issue for them because this is a grantor trust. So from a public information point of view, the only thing a individual would see if they pulled up the property transfer records on the county recorder's database is that you own the property and you put it into a trust. Now, that trust in and of itself, the land trust, does not provide any asset protection. So it's a mechanism by which we transfer real estate into an asset protection entity, which is an LLC, without alerting the general public as to the full nature of our transaction. So after it's in the LLC's name, or the land trust name that is, you then assign your land trust interest over to the LLC. And then the LLC owns the trust owns the property. If anything happens with respect to that property, it is the LLC that picks up the liability and you're protected.
Okay, cool. Thank you.
All right. You're welcome. Have a good day. All right, let me try Anna again. She's still not there. All right, so we're going to go with Richard. You'll be the next one up. Richard Guzman?
Hello, can you hear me?
Yeah, I can hear you.
Great, good afternoon. Good to hear from you, Clint. Got a quick question, and hope it doesn't come off the wrong way, but I recently got my LLC bills in the mail, and I'm like getting second thoughts, like, why did I do this? Because I have 4 rentals, and I couldn't get the loans through the LLC, just like the previous caller. I couldn't apply or qualify for a loan through the LLC because I didn't have any business. I didn't have 2 years tax return, whatever the banks were asking for. I didn't have it. So all my properties are under my name. There was one estate sale that's owned free and clear, no mortgage, but the 3 other rentals all have loans on them. So I'm like, wow, why do I got these LLCs and then the cost of it, et cetera, et cetera? Can you just please share, and I hope you have some kind of data, like your clients, I mean, how many of them report, lawsuits or claims? I just want a percentage. I mean, is it 10%, 5%? I mean, should I be worried more when I get 10 properties and then deed these properties over, or should this be immediate action? Just your thoughts on that, please. How many clients really deal with this kind of issue?
Well, the way I look, it's a difficult statistic to nail down. How many of our clients get sued? If you're asking that question, I can tell you very few are ever sued. Now, why is that? I mean, it's hard you can't really predict because we don't know the motivations behind someone who necessarily would bring a lawsuit. But I could look at those statistics and say, well, there's a strong correlation between asset protection and being sued. That is, when somebody is considering bringing a case against an individual and they see that that individual is fully structured, the attorney knows that the likelihood of a favorable outcome from a collection standpoint is greatly diminished. So if you're considering, do I take the case where even if I win, I lose because I can't collect, or do I take the case where everybody has their assets in their own name? Well, I'm going to take the case that wherever that person has all their assets in their own name because it's very easy to collect against those individuals. And so the way I look at asset protection is that you're setting it up, it's a form of insurance, that if something, A, it's going to, hopefully prevent someone from coming after you, but B, if they do come after you, you haven't risked all of your savings, your investments to that one lawsuit. Because at the end of the day, I mean, personally, I invest in real estate to build up a retirement plan and a legacy for my family. And I don't want to see that jeopardized by one mistake that's made either personally in my business or if something happens on the property itself and then somebody brings a claim against me and then I do not have the assets or the insurance to cover it. Because many attorneys will tell people, oh, just buy extra insurance. Well, first off, how much insurance do you need? And B, will that insurance cover you in the event of a lawsuit? Many claims with respect to real estate now are environmental, and environmental claims are not covered by your policy, so you're on your own. And then depending on the state in which you live, we have even other problems there concerning how they view liability. For example, take California. They have what's called joint and several liability. So you could be in a situation where you think you are completely in the clear, that there's no way someone could hold you liable. But in California, for instance, if you are 1% negligent, if you can get the jury to believe that you were 1% negligent leading to the cause of action, then you can be held 100% responsible for the damages. And I've had clients in that situation. I recently settled up, or I settled up a situation with a client in California where he was protected, but his father wasn't because he wasn't a client. And the plaintiff refused to settle with the father because he saw that he had all these assets in his own name. He said, you know, your dad's worth $30 million. I'm not settling for the insurance. We're going after him for cash as well. They settled with my client for the insurance premiums, so the policy, I mean, not the premiums, but the policy. But they went after his father for more. And his father, it's in one of those situations where his father didn't do anything wrong. But they knew if they could get a jury to buy off on the fact that he was 1% negligent, they could have him. So
wow.
It's really, I mean, if I told you you don't need asset protection and then you got sued and they took the assets away from you, then you could possibly come back and sue me and say, well, I was based on Clint's advice.
Right. No. I get those every time I get insurance on a new rental. The insurance company always, you know, pushes that umbrella on me, and I'm like, not yet. I don't think so, but I think I'm approaching that situation there.
You know, and also keep in mind, you don't need to have one LLC necessarily per property. That's a personal choice. You might want to just group your properties initially into LLCs, maybe 2 to 3 doors per LLC, and then you grow from there. So if something does happen, yeah, your real estate's at risk if you had 3 properties to begin with and they're all in one LLC, but all your personal assets are protected, or vice versa. You know, you do something wrong and they sue you personally and they get a judgment against you. Well, your real estate's now protected from that because it's in an LLC and they can't take it from you.
Okay, the key is just registering with the Secretary of State, the foreign LLC. Is that what I need to do?
That's it. Make sure it's up to date and you're good.
Okay, just one real quick thing. The tax returns, is it common for my first year tax returns on these LLCs to show losses? I mean, I plan on claiming these traveling and some other things, you know, as far as these rental properties I purchased, or is that out the question?
No, I would do it. I would take those expenses against the income generated from the property, so that would be normal.
Okay, got it. Thank you, Clint.
You're welcome, Richard. Take care. All right, I'm going to go over now to Tim Johnson.
Hello.
Hey, Tim.
How are you?
Good, thanks.
One really quick one and one that might take a couple minutes longer. The first one is I set up 2 LLCs in Colorado to hold rental, long-term rental property, and then I have the Nevada holding company. You guys set all that up for me last year.
Mm-hmm.
I'm transferring one of the properties in. Do we use a warranty deed or a quitclaim deed?
Warranty deed.
Okay. Now, my other question then is going to be, so with the 2 LLCs that go to the Nevada holding company,
mm-hmm.
I've got some other expenses that I'd like to put in, like long-term health care and stuff like that. I know that's not deductible through the partnership in Nevada, correct?
Correct.
I was thinking of opening up a C-corp that basically managed the Nevada LLC. Is that a good way to go? And then run my expenses through that?
Are you going to continue to invest in Colorado?
Yes.
I would open up a Colorado C corporation.
Okay.
I would have that Colorado C corporation manage your 2 Colorado LLCs.
Okay.
And if you're going to say you come across a flip in Colorado, then I would flip it through that Colorado corporation. If you create another Colorado LLC for additional properties, I'd have your corp manage that new LLC as well. Now we've got a company that can start collecting an income stream from your existing assets. Take that income stream and then start expensing out the income, picking up those expenses you just brought up during this call.
Right, and mostly what I was looking at doing with the C-corp is just putting enough money in there to cover all those expenses that I want to.
See, that's the perfect strategy. So now you're netting it out every year, and it doesn't show up on your tax return. So if a lender, when you go in to apply for a loan, they're not going to even see this company. They won't even know you have it. Whereas if it was an S corporation, it would show up, and then they would see that it makes no money, and then they would be, that's going to increase, or it's going to make it more difficult in some instances to get a loan, because they will then view you as a riskier borrower.
Okay, well, I thought about this, and I thought I was right, and I just wanted to clarify it and make for sure that's a good way to go. But you think a Colorado is better than a Nevada corp for that?
For what you're doing, yes, I would set it up in Colorado.
Okay, great. Thank you.
Oh, you're welcome, sir. Take care. Carol, how are you doing?
Hello?
Hi, Carol. It's Clint Coons.
How are you doing?
Great, thanks.
We have an LLC that we've had for a little over a year now, and we've been advised by Anderson to apply for the C-corp, whatever categorization this year. We have a lot of educational costs, flipping formula and, different educational programs. How exactly does that work? How exactly do we pay ourselves back for that?
All right. When you set up a corporation, you become an employee of that corporation. Now, your expenses that you've incurred, so you're over here, you personally paid for the education on your own. What you're going to do is you're going to treat that as yeah, exactly. You paid for it with your personal card, right?
Mm-hmm.
So let's assume that you paid for, I'm just going to use $20,000 here. You spent $20,000 on education. We're going to treat that as an expense of your newly formed corporation, as a pre-incorporation expense. Then what happens is when your corporation starts to generate income, you will begin to reimburse yourself. So let's assume I made $5,000 in my corporation. So my corporation brings in $5K. It would then pay me out $5,000 to start cutting down on this 20. The $5,000 it pays me is the deduction to the corporation, so I have zero income now, and the $5K that I receive is not taxable because all I'm doing is reimbursing myself for an expense that I incurred on behalf of that company.
And it's okay that the expenses were done in 2015 and the corporation wasn't established until 2016?
Correct. Where we run into problems is in situations where the expense is more than a year from the date of incorporation. Then you cannot argue that the expense was incurred with the anticipation of beginning a business because it took too long for you to form your business.
Okay.
And then keep in mind that this carries forward. So if you don't make the 20K this year from your investing, that expense or that cost will roll over to next year for 2017. And then if you make money in 2017, then you can just reimburse yourself and deduct it as well.
Okay, so we had one cost, one educational program that we joined in December 2014. Because we're in California, we waited to establish our LLC till 2015, so we could avoid the $800 tax for 3 days of business, whatever. So are you saying that the expenses in 2014 probably are not going to be reimbursable?
I'm going to ask you another question. Do you own rental real estate?
Yes.
Take the expense on your Schedule E.
Take the expense on our Schedule E personally?
Yes.
Okay. For the training, for that one training on our Schedule E.
Yes.
Okay. Did you have another question? My husband's here as well.
Is it okay to ask another question?
Yeah, go ahead.
Dealership. We found out the term dealership. this past week, and I've done some reading on it and a little more confused than I was before. Could you explain the dealerships, the benefits and the drawbacks, and how to avoid and how to use to your advantage?
Okay. So a dealer, can you pause or mute your speaker because I'm getting feedback?
Certainly.
All right. So a dealer is someone who engages in real estate on a short-term basis. And so what we want to do is set it up so that you are not flipping property in your own name, because if you're tagged as a dealer individually, then all of your income associated with real estate is going to be active income to you. Now, how will that affect your other real estate investments? They could deny your depreciation deduction from your property. They could deny you long-term capital gains treatment. So we want to avoid you being classified as a dealer, and the way we do that is run that activity through a corporation. So the corporation becomes the dealer, not you individual. On an individual basis, I'm always going to be an investor. My corporation will be the dealer.
Okay, so that's the distinction. I heard that we didn't want to be a dealer, and now the C-corp is my dealer.
That is correct.
Okay. Thank you.
You're welcome. Take care.
Thanks. Bye.
All right, I'm going to take one more call here. Todd, are you available?
Yeah. One quick question related to their last question on the LLC and the education. If we did have a rental property in the last year, we've had an LLC for a number of years, we could take that, you said, on our regular tax return? Personal tax return?
Education expenses?
Yes.
Yeah, if you have a rental property that you've had for a year and you incurred the educational expenses after you acquired the property, then I would recommend you take it on your Schedule E, bury it on the Schedule E, because it's treated as part of your investing. That you obtain this additional education so you can become a better investor. I see no
so I wouldn't have a tax advantage to go ahead and put the C-corp in place and run it under that, because it was just within the last 4 months.
Yeah, I would just run it on your Schedule E then, rather than run it through the C corporation. Now, if your expense exceeded your income generated off that rental property, then there may be an issue there as far as trying to claim it all. But the other thing I would look at is, where are you taking your investing? If your investing is all going to be buy and hold, and you're not going to be engaging in any flips, and you only have one property right now, putting together that C corporation isn't going to necessarily benefit you, because it's not going to generate enough income to reimburse you unless you change your style of investing to a more short-term based investing strategy where you're generating income inside of the corp, or you have properties that you can pull a management fee off of that would then create the income.
Okay. Well, we're working on your questionnaire with Bob, but we're trying to make sure we have everything set up correctly. One of the things, when we're gone on vacation, sometimes we'll rent our house out, and I want to make sure that we, through like Airbnb or VRBO type thing, want to make sure that is protected. I'm assuming through a land trust somehow, but could you sketch that out and just let me know? So we have the one rental, then we have our own home, and we want to make sure that all of those get positioned correctly and set us up for some other investing down the road.
So your rental would be in a land trust. Your property would be in the land trust. The land trust would be held by a limited liability company like this. Your personal residence, is that the one you rent out on Airbnb?
Yes.
Then I would create a second land trust for it, and I would run this into the LLC as well. Now this LLC will be a disregarded LLC, meaning it will not file a tax return. And by setting it up that way, we preserve your 121 gain exclusion. So when you go to sell your personal residence in the future, you do not jeopardize it.
Okay. And then that that same LLC for the holding could handle the rental and anything else we put in there.
And then that would flow down in your living trust.
Okay.
Just like that.
Okay, great. That was my question. Thank you.
All right. Well, great, guys. We've come to the end. I want to thank you all that joined the call today and asked some great questions. As I stated, I'm going to take this recording and I'll put it up on my blog later on today. You can get there by going to clintcoons.com, and you'll see a link to my blog in the right-hand corner. So if you want to listen to it, watch it again, it's going to be available to you. And by the way, you're going to get a lot of great information there. Many of these questions have been answered through some of the articles I've written over the past several years. You can search the blog. Be sure to sign up for updates. So whenever I post a new article, you'll be notified of it. And then if you're not working with Anderson and you'd like to get this type of access to information on a daily basis, you should consider joining our Platinum program, where we make ourselves available to our clients to answer their questions, answer their emails, give you access to our CPAs to ask your tax-related questions for a very low monthly fee of $35 a month for our Platinum clients. Plus, we have a tremendous amount of information on our back end of our site where you have access to forms and videos that are available to further your education as it comes to investing and protecting your assets. So with that, I'm going to sign off, and I look forward to seeing you or hearing from you next Wednesday for my next office hours. Take care. Bye-bye.